They put that special controller on there, I'm sure my just automatically turns them off. You don't have to turn them in, but they can use the way we got it. And the ones that want quicker, well, they're not participating, well, that's not gonna be one. I know I've seen that thing from, Chicago, Illinois, them poor people, I mean, that age, what they're doing.
Okay, that's the way it's written now.
What bothers me again is, you know, the policing of it. If we put 30 hours in, who's gonna do the measuring? Who's gonna sit there with his watch and then somebody else will have to verify it?
Well, the problem that I have with forcing everybody to put those anti-liquor controllers on is that, you know, forcing somebody to put something on that may not be a problem.
Well, if it ain't no problem, then we'll shut it off.
Yeah, but it's
Cost.
it's a cost. I mean,
On every one of them.
but I
You don't have to put them on everyone, just the non-participate. The ones that are participating, you're willing to take it, yeah, that's why you're participating.
Yeah, but a participating parcel may cast a shadow flicker on a non-participating parcel.
We don't have any now, we wouldn't want to fight for some. They come into the township, we have to write the ordinance to please them.
We did that, we wouldn't be doing that.
Okay.
No, you have to write, let me just correct that. You have to write a reasonable order. That's what you have to write.
Is there language that we could put in there? I mean, I don't believe that we need to put the software in every one of them. But I think there needs to be some regulations that state how long this goes on before software is installed. In other words, I don't want it dragging on for months while they prove whether or not the person's affected by the shadow flicker or not.
Well, so how long is that? Because I think, take 30 hours, for example. 30 hours, I think, represents roughly 3% per year. Okay? That means 97% of the time it's shadow flicker free. And even then you've got roughly, you know, that it's hard because obviously the conditions have to be right. So it will happen in the early morning or late afternoon when the sun is low in the horizon. And the wind's got to be blowing. And it's got to be sunny, which in Michigan eliminates half of that right there. So, but so you have to have those three events coinciding at the same time. I can't tell you whether 30 hours or not is reasonable. It seems to be, if you look around the country, it seems to be sort of the norm in terms of permission. But I can certainly see where you would want to have safeguards in place so that people are not subjected to that on an unreasonably amount of time or for an unreasonable amount of time. Is that 30 hours? 3% of the year? Or is that 15, 1.5%? I don't know the answer to that. I think, you know, you're going to have to either say, well, we're going to allow some, limit that, whatever that may be, and then if it's over that, then you need to install this software to eliminate, or to bring it back under that, either 30 hours, 15 hours, or zero. Zero, obviously, it's like everything else, right? Zero, you trend toward unreasonable. 30, you're at more reasonable. So, you know, depending, there's no guidelines for this. It's not as if I can tell you right now what's right or wrong. So I can only tell you that if you're that person that's getting 50, 60, 100 hours a year, you're not going to like it.
Yeah.
Is 30 hours a year too much? I have no idea.
For some people, it probably could be.
That's right. And like I said, You may never reach 30 because the conditions have to be just right for it to happen.
Yeah.
It won't be true.
But to install software, mandate that the software be installed in every turbine. I'm not sure how reasonable of an expectation that is, but by the same token, I don't want to see somebody putting up with, if we set it at 30, that should be the maximum. How do you regulate that?
Well, it's like anything else, you're gonna have to, you're gonna have to monitor it. I mean, there are items in here that you're going to have to monitor. Noise and shadow flicker are two of them. I mean, there's no way getting around it. Otherwise, you just say, these are the limits, please don't exceed them, and let them loose. Well, so if that's the case, then you're gonna have to take some proactive stance, and we to the extent we've tried to draft language that provides you some incentive to only investigate those complaints that the township board deems to warrant an investigation. Because right or wrong, you will have people who just want to complain. Okay?
Not in this township. Not in this township.
So, we'll get to this, but the enforcement mechanism is set up where if the township board receives a complaint and they deem it sufficient to warrant an investigation, they will demand or request a deposit from the developers, which they have to give to the township. The township will hold an escrow. If they are in violation of the ordinance, they pay, and they have to bring it into compliance. If, however, they are not, or they are in compliance with the ordinance, township pays. So that creates some incentive for you to make sure that you are investigating only those complaints that you deem warrant an investigation. And that will require you to do your own due diligence to figure out whether there's a potential violation.
Well, if they were out of compliance, say for an example,
Sue them. Yes, it's a nuisance per se. The violation of your zoning ordinance.
compliance, they have to shut the mill down, put the control on.
It's a nuisance per se, it's a violation of your zoning ordinance.
By the time
The only question
it might take 2 years to do that.
Maybe, but the only question there is abating.
If they had that mill shut down, if he meant he was out of compliance, I bet the dollar they wouldn't take that long. Put some teeth in it.
There are teeth in it. What more would you like me to spank them too?
If they're out of compliance.
Look, if they're out of compliance, you either write a citation or you sue them. In any case, every case. What else would you like to do to them?
Well, it might take 2 or 3 years before you get the court.
Yes, that's not my
What
problem.
about that victim that's hidden?
That's the judicial system. I can't ask them to go faster.
No. We can stop that mill when he got it fixed, they could still come in compliance.
How are you going to do that?
Shut it off. Turn it off.
It's the same issue in saying to them, look, bring it into compliance. What if they say no? What if they say, no, we're not going to shut it off? You sue them. If they fail to do what you ask them to do in terms of the ordinance, you sue them. You file a complaint, you file a motion for injunctive relief saying abate the nuisance and do it now. Then the judge gets to decide. That's how you go about it. That's how you go about any zoning case.
I'm open to allow 30 hours a year with a waiver privileges for both participants and non-participants. I kind of made notes on, when I was reading on to here. At least they'll give you 30 hours, it won't be that 0.
I'll second that.
Well, why are we waiving?
Well,
What do we-
they have the right to waive if it gets to be a problem. That could be a mitigation that they could waive their rights if they're participating.
But if they waive it, that just means that they're accepting the flicker. If they're
That's
accepting
correct.
the flicker, there's nothing to waive.
Well, but if If it goes beyond that 30 hours, he might have a legitimate complaint.
But if he's complaining, then
They could waive
And again, they can waive it with,
to allow a greater amount, or no limit, I suppose.
okay, so they could waive to a greater amount.
I mean, that's a potential.
That's an option.
Right now it's set at 0,
Yeah.
so you could waive it to a certain amount. But I suppose you could even do that with a limitation of 30 hours. That you could, 30 hours are permissible under the ordinance, but if you're a non-participating parcel and you want to waive that and allow 60 hours or 90 hours or some other limitation that you want to put on the waiver, then they could do that. So the only question is, I suppose, if you're going to allow 30, then are you going to set a maximum on the waiver? I mean, I don't think there's a reason to after that, is there? If somebody's waiving, they're waiving for whatever they get.
I see, so there could be a monetary attachment to that waiver.
And I'm sure there would be.
Yes,
Right.
okay, which will go back into 2 years, you can still be non-participating, but still waive. Okay, that rolls fine.
Are we gonna still mandate the software installed on every turbine?
I guess it's probably a software, there's a presumption of guilt already before it starts.
But that's what the ordinance states.
Yeah, the way it's written now.
I thought I had included 30, I would be willing to compromise it.
And then, like you said, maybe when it gets to that 30, the first step should be that, that equipment has to be installed on that unit. If they don't waive their rights.
Correct.
Okay.
You have to reword the paragraph.
Well, the existing paragraphs suggest that everybody that's not participating gets a piece of equipment, which can be financially accessible.
I agree.
I guess my take on this whole thing is that anybody that is suffering from either noise or flicker, to me, one of the things, and that jumps right into complaint resolution, I feel, especially after listening or talking and when we took that trip to the wind farm in Ubley, that people were complaining, and then Paul, you brought up the gentleman in DeKalb County, the inattentiveness that the developers were paying to people that were complaining. And I think to me, it is absolutely necessary that we address complaints in a timely manner so that people, A, know what the procedure is to file a complaint, and 2, that it's handled in a timely manner. Bearing in mind that we cannot speed up or slow down the court system, but, we need to have enough teeth in the resolution process then to help mitigate the problem. And if that, I don't know how we want to write that, if that would take in this technology. That's not me. So, if we need that to mitigate this, whatever the flicker is, that the software would do that, then then that would be part of the mitigation process.